Welcome to the First District Court of Appeals. We have three cases that are set for argument today. I'm going to go through the cases, and if the attorneys would please, and the parties, I know we have one pro se party, would identify yourselves and your readiness to proceed. I'd appreciate it. The first case we have is C250077, Rialto versus USLBM.
Good morning, Your Honor. John Finney on behalf of the appellant, Rialto.
Great.
And my colleague, Kelly Coker.
Hello.
Good morning, Your Honor. David Hine on behalf of USLBM with Kristen Riley and Evan Sumner as well.
All right, good morning. The second case we have set for argument today is C250226, Cortland Gundling versus Cincinnati Metro Housing Authority.
Good morning, Your Honor. Portland Gunling.
Good morning.
Good morning, Your Honor. Edric Jones on behalf of CMHA.
Okay, great. And the final case we have for argument is C250197, State of Ohio versus Preston Lee.
Good morning, Your Honor. Laura Peters on behalf of the appellant, Preston Lee.
Good morning, Your Honor. Ron Sherman on behalf of the state of Ohio.
All right. All right. Mr. Pinney, would you like to reserve some time for rebuttal?
I would indeed, Your Honor. I'd like to reserve 2 minutes, if I may.
You may. Let me just set that up real quick. All right, whenever you're ready.
Good morning. My name's John Pinney. I'm appearing on behalf of Rialto on Hurstbourne. This case involves a 268-unit luxury apartment complex in Louisville, Kentucky. Because of a forum clause, the case is pending here in Hamilton County under the parties' contract. USLBM, the appellee, was the project's materials supplier under an express agreement providing that USLBM would supply virtually all of the building materials required for the project. Those materials included the subject material, the subject item in this case, Extreme Green.
And this was an agreement that Rialto drew up and provided, correct?
Yes.
Okay.
It was Rialto's form,
Yes.
and USLBM agreed to the terms, including, critically, the express warranties contained in that agreement. The problem with Extreme Green is that, according to Rialto's experts, Extreme Green was the culprit in the assemblies between the floor and the ceiling of this multi-story apartment complex.
How do we know that from this record? My understanding is that the Extreme Green product was installed in a floor ceiling assembly.
Correct.
And then it was not taken apart for the purpose of inspecting it. So how do we know that Extreme Green was the culprit of the problem?
Well, first of all, the experts so opined. Secondly, and perhaps even more importantly, they are experienced in this, and according to their opinion, sound transmission characteristics may only be properly assessed and determined in the assemblies as constructed. Now, they did disassemble certain of the assemblies to determine, for example, that it was properly constructed, that there were no anomalies other than the so-called tried and true materials in there, with the exception of Extreme Green. They opined to a reasonable degree of engineering certainty that the cause of the excessive sound transmission was Extreme Green.
And my understanding of this expert report is that there was a metric that came back at 45, and that is below both the luxury standard of 60 and then the average building code standard of 50. Can you address that?
Yes, Your Honor. Actually, there were two different criteria that were assessed. Well, one had to do with a static transmission of sound like voice. Another was impact transmission, such as heels on the floor and the like. Both of those tested below the Kentucky Building Code standard on average. One was significantly below, one was close to that standard.
And is the problem that the product performed below the building code standard or below the luxury code standard?
I think both. I mean, it clearly, in the aggregate, was below the Kentucky Building Code standard. But moreover, this was built and marketed, and the defendant, appellee, knew that it was a project that was indeed intended to be a luxury apartment complex. And consequently, we submit that the evidence would suggest that the proper standard would be the luxury standard or the higher standard.
A further question on that point. In the Skoog affidavit, there is a representation that Extreme Green's marketing materials identified that its IIC rating was 55 and its AIIC rating was 50. So if Extreme Green was being held out by the product manufacturer as being at a sub-luxury standard, how would the luxury standard then apply here?
I mean, I think that would be a jury question, Your Honor. The issue is not, however, what the Extreme Green manufacturer and distributor represented. The issue is whether or not this particular product, in fact, met the warranties that were in the contract between Rialto as the owner and US LBM as the supplier. The contract is really the focus of the issue in this case, and whether or not the warranties, the three particular warranties, including the design defect issue, the merchantability issue, and perhaps most importantly, the suitability issue of Extreme Green for the function that it was designed to do. It's immaterial whether or not the seller, in this case, US LBM, represented anything. They were making an express warranty, and the evidence we submit created a basis to show that they breached all three warranties, or even if they only breached, according to a jury, one of those warranties, then there would be a breach of contract giving rise to a legitimate claim for damages.
Didn't your client insist on this Extreme Green product being used in the design?
They certainly did.
And isn't there an exclusion under the design warranty if your client insists on a particular design?
No, there is not, Judge Moore. The exclusion, which is in the language of that warranty, says if the owner provided detailed design specifications with regard to the product, in that instance, that warranty would be excluded. None of the others, but that warranty would be excluded.
So what would be an example of that?
Pardon?
What would be
an
an
example? In fact, there was an example specifically under the contract with regard to the stair treads and the trusses that were used for the superstructure of the apartment complex. Those did provide specific design details, and that design exclusion would apply with regard to those. But simply stating that Extreme Green was to be provided only stated its trade name, and as a consequence of that, there was no basis to exclude the design warranty with regard to Extreme Green. Further answering Judge Moore, Extreme Green was a product that was chosen by the owner, to be sure. But the key point is that US LBM agreed to the contract with the express warranties. And under the UCC, those express warranties apply whatever their knowledge with regard to the particular product. They could have negotiated that out of the contract. They chose not to. That's in the contract. If it's breached, they have liability.
And they could have walked away.
Indeed. And, I mean, the argument that they make in their brief, I respectfully suggest, is nonsense. And that is because they said, well, we were contractually obligated to provide it. We would have breached the contract had we not provided it. Well, of course. But they signed the contract and made that agreement. I'd like to turn, if I could, to the issues regarding summary judgment, because really that is the crux of this case. As this court is well aware, the standard under Rule 56, 56C in particular, requires that a movant affirmatively show that it is entitled to judgment as a matter of law based upon the facts, viewing those facts most favorably toward the party opposing the summary judgment, and only reasonable minds could come to that conclusion in favor of the movant. The submission by U.S. LBM in its motion for summary judgment, we suggest, did not meet the standard required under 56C to trigger an obligation by the party opposing, namely Rialto, to provide evidence to create a genuine issue of material fact. In this case, one can look at the expert evidence submitted by Rialto, both as meeting its burden, but not responded to by U.S. LBM by their expert, Mr. Montalto, who did not submit anything that was verified or by affidavit, and consequently, there was no rebutting evidence or 56E evidence submitted by U.S. LBM. In connection with that, as a consequence, the posture of this matter is that this court should reverse the judgment of the trial court because U.S. LBM did not meet its obligation under 56C. And therefore, its motion must fail for that reason alone. However, if the court were to find that there was sufficient evidence to trigger the response, at a very minimum, the expert evidence offered by Rialto would have created a genuine issue of fact on liability for trial. So that is the manner in which this case comes before the court. I cite the well-known Dresser versus Burke case. I also cite the Dytek versus Bulumunkwi case, which I argued before this court some 7 years ago.
So Rialto also filed for summary judgment on liability.
Only liability, yes.
And would you
Your Honor.
agree there's also a genuine issue of material fact?
I'm not
with regard to
conceding
li-
that. I'm dealing with it primarily procedurally, Your Honor.
Okay.
And I'm dealing with it procedurally on the basis that Rialto filed for summary judgment, supported properly under 56C, which in turn triggered an obligation by U.S. LBM to respond and to then submit evidence to refute the
And you're saying
evidence
they
submitted.
didn't submit
They
evidence
submitted
to-
nothing that was verified or properly submitted under 56E, requiring it be by affidavit or otherwise verified in deposition or the like. And we submit that that was not successfully done. And it has to be directly responsive to the expert evidence submitted by Rialto. I want to, before I conclude, I'd like to...
You have less than 30 seconds if you want to keep your 2 minutes.
I'd like to address, Your Honor, the indemnity provision, which is not limited to third-party claims, but a breach of warranty. Where there is a breach of warranty, the defendant is liable for all costs and expenses caused by the breach. For these reasons, we respectfully request that the court reverse the judgment of the trial court dismissing the case, further reversing the judgment of the trial court denying Rialto's motion for summary judgment and include reversing or vacating the decision with regard to the third-party indemnity. Thank you.
Thank you.
Morning. May it please the court. There are a number of reasons why summary judgment in favor of USLBM was appropriate and why they remain appropriate today, such that this court should affirm the trial court's decision. The principal reason, and the reason that Judge Gehring seemed to focus on, is that the contract at issue in this case does not require of USLBM what Rialto claims that it does. Or put another way, the conduct at issue, specifically the provision of Extreme Green MGO, is not prohibited by the contract. It does not constitute a breach of the contract, and it is in fact required by the contract. That is set forth in the contract itself, which specifically calls for Extreme Green MGO by name, and it's not simply the trade name, it is the dimensions and everything that goes along with that particular product. It is also established by the sworn testimony of Rialto's 30B5 representative, Seth Gutman, who acknowledged that it would have been impossible for USLBM to comply with this contract had they not provided Extreme Green MGO.
Right.
But by providing that, didn't they assume responsibility for that product? Wasn't it your client's responsibility to investigate Extreme Green to make sure that it was appropriate for this project?
No, Your Honor, and that's to go back to the question that you asked Mr. Pinney. And I think it's important that we back up and we understand exactly what the defect is that's at issue here, right? And because that matters in terms of which warranty is actually implicated. What Rialto claims is that Extreme Green MGO does not provide the sound attenuation properties as advertised by the manufacturer and the distributor. That is a design defect. It's an issue with performance. So we look to the provision, Section 3B of the contract, which addresses design defects. And it says that USLBM will warrant against design defects except to the extent that the product complies with the detailed designs provided by the owner.
Well, that language modifies the design warranty, but it doesn't modify the merchantability and suitability warranties.
That's correct, Your Honor, but the suitability of a particular purpose is not implicated here, neither is merchantability. Although they invoke
Why
those-
not? I mean, they're claiming that it is.
That's right. So they do claim that it is. Merchantability, Your Honor, the warranty against merchantability pertains to the physical quality of the product at delivery. So the example that we used in the trial court is if you're building a house and you order windows for your home, and they show up and the glass is all smashed out, that's a merchantability issue. No one would buy that. It's not merchantable. If it shows up, though, and the product is in form, the glass is there, but when you install it, it doesn't provide the same heat insulation, that's a design defect. Those are very different things. And it can't be that
So are you suggesting that the suitability warranty is redundant of the design defect warranty?
no, I think that the way that Rialto is trying to invoke all three warranties, that results in a redundancy. I think that they are actually very distinct things. So for example, if Extreme Green MGO had been delivered to the product at construction and it had holes punched in it and it was cracked such that it couldn't be installed as a subfloor, that would be a merchantability issue. There were instances where Extreme Green MGO actually did break. The undisputed evidence is that's because it was left out by Rialto in the elements and was rained on, became soft, et cetera. But in those instances, they called USLBM and they provided more product. That's an invocation of the warranty of merchantability. That's not what they're complaining
So
of
wait,
here.
warranty of merchantability is they're a fit for the purpose for which they're ordinarily used or sold, right?
That's correct.
Okay, so
Well-
this is flooring,
That's right.
and it's not even meeting the design, the standard for the building code.
No, Your Honor, I don't think that that's correct, and I think that this building was actually approved by the state of Kentucky. It did meet the building code. The testing that they came up with afterwards was not performed at the building. It was performed on a different installation, an assembly that they provided in a lab that actually didn't even meet the dimensions of the assembly that was used in the building. So there's no evidence at all that the building doesn't meet the building code. And in fact, the evidence
No,
indicates.
the flooring.
Well, the flooring that's in the building.
Soundproofness of the flooring doesn't meet the minimum standards.
Right. So their two experts said that the assembly, an assembly including Extreme Green MGO, prepared in their lab, didn't meet, in some instances, the building code. That is not the same thing as saying that the flooring in the building didn't meet the building code. This building was approved, it is occupied. It does meet the building code. It has been occupied from construction, it has a 98% occupancy. It is a fully operational building. There is no actual allegation that the building was somehow failed to meet the building code because of this product. What they are arguing is that in a lab, they created a situation where it didn't reach the building code. That's an important distinction, because neither of these experts ever actually did anything to test the actual assemblies, and neither of these experts did anything to test the actual product or to isolate the product as the reason why this mock assembly that they created in their labs didn't work. But I want to go back to the question Your Honor had about the other warranties and the suitability of a particular purpose. Both of these two provisions that we see in Section 3C they're derived from, I think it's Section 3 or 2-314 and 2-315 of the UCC. There is ample authority on what those two warranties mean. It's not a design defect, which is what they are complaining of here. The suitability for a particular purpose is a situation where the buyer relies upon the expertise of the seller to use a product for some reason other than the ordinary purpose. That fundamentally didn't happen here for a number of
And
reasons.
what was the purpose? I understand their claim to be dual in the sense that there was a luxury standard they were attempting to meet and then the ordinary building code standard. What was the purpose of this product with regard to those standards?
With regard to those standards, Your Honor, I don't know that there's any evidence in the record whatsoever as to what their intention was. I think that the purpose, the use of the product was to be used as a subfloor, which is what it is. It's a subfloor. If they had come to our client and said, we're going to use it to build a skateboarding half pipe, can we do that? And our client had any familiarity with the product and said, yeah, go ahead, that would be.
And is the purpose of this product merely to provide floor ceiling support such that the ceiling is not, or that the floor is not falling through the ceiling? Or is it to buffer sound between those two levels in a multi-unit building?
Well, Your Honor, if you look at I'm qualifying here only because my client has no functional idea, and that's undisputed in the record, that my client had no familiarity with this product, made no representations about it. If you read the manufacturer's literature, I think that it serves a number of purposes. The primary reason, and the reason why the owner chose to buy it, was not because of a sound attenuation issue. It was because the alternative, and every other building that they built, used what's called gypcrete, which is a self-settling liquid that gets poured into about 3.5 inches above drywall, or plywood rather. And it can be very messy, it can leak down into the floors below, and it can take a long time to build upon. This is a cheaper alternative to that, in that you just nail it down and presumably can continue to build. So it saved them a ton of money, rather than having to pay for gypcrete and take the time to delay the building process. That's why they bought it. There is, I believe, somewhere in the literature, a representation about sound attenuation or acoustic insulation, but even their own experts make clear that that system from ceiling to floor between levels is all involved. There are, I think, 8 inches of insulation that's included that goes along with, that attributes to that acoustic insulation. There's something called an RC, or a resilient channel, which places a gap between materials. That is also a sound buffer. There are a number of things that go into that assembly that are supposed to accomplish sound attenuation, and it's a fallacy to suggest that this product was supposed to accomplish that in and of itself.
So you're arguing that the warranty of merchantability and fitness for purpose does not apply here?
That they were not breached here.
They were not breached,
that-
and it was
that-
a design, like, the only thing we should really be discussing is whether there was a design defect.
It's the only thing that they allege, Your Honor. It's the only thing that they present evidence of, is that there was a design defect here. That's right. And because the design defect it specifically provides an exception for this situation. And I want to back up and make clear that why that exception is there. If you look throughout this contract into the attachments to the contract, there are a number of instances where USLBM was required to provide certain materials, but they were afforded discretion. So for example, I think that all windowsills are supposed to be 1 by 8 inch poplar wood. Where USLBM sources that from is up to them. If they go to a particular source or a particular manufacturer in order to save costs, so be it. But they're exercising their discretion in order to satisfy that term of the contract, and they thus bear the responsibility of ensuring that they have done the due diligence to make sure that it's an appropriate product, and that if there is a defect in it, they will warrant against it. Extreme Green MGO, there was no discretion. They could not comply with the contract without providing it.
But they could have walked away from this deal.
Your Honor,
And you said your client has no idea about when they entered into this agreement, they had no idea about the qualities of Extreme Green.
that's correct, Your Honor, and that's undisputed in the record.
So haven't they assumed the risk of going forward with this contract using a product that they had no idea about?
I think, Your Honor, that they assumed the risk with regard to certain warranties, but not to design defects for that very reason. That's why that provision is there, because they do not have the discretion. The idea that we could walk away, if you take that argument to its logical conclusion, Your Honor, this contract is nothing more than a piece of paper that required USLBM to provide all of the supplies to build a $35 million project, and in return for that, pay $46 million. There's no other conclusion, because they either breached the contract by not providing Extreme Green MGO, or they breached the contract by providing Extreme Green MGO, and if Rialto is to be believed, then have to pay $46
Well,
million.
you're saying the contract has an exception because of the design defect provision. And it talks about, except to the extent that such items comply with any detailed designs provided by the owner. How is this a detailed design provided by the owner?
Because they provided the blueprints, Your Honor, and the blueprints specifically call out Extreme Green NGO 3/4 inches by name. They are, it is again undisputed, Rialto's corporate representative acknowledged that those are the most designed details, or detailed designs that exist. They literally used those documents to construct these buildings. Extreme Green MGO is specified by name in the blueprints. It's literally impossible to build these buildings without Extreme Green MGO. There is no alternative product. If they don't use Extreme Green MGO, they have to pour gypcrete. That adds about 1.5 feet to the height of this building. That's not a rounding error. It would be on each floor 3.5 inches.
So anytime the owner would call for a specific product by name, then that would be considered a detailed design under the contract?
I think that any
what you're
time
saying?
that the detailed designs specified what product needed to be included, then yes, that would fall within the detailed.
Okay, of a detailed design specified a product, not just the specification of a product equals detailed design.
Absolutely, Your Honor, yes. It's important. We point to the fact that the contract does specify Extreme Green MGO. But I think that the invocation of that detailed design exception is pointing to the evidence that indicates that the blueprints were provided and that the blueprints, the most detailed designs, call for Extreme Green MGO. That's the thrust of that, is that the blueprints themselves call for it.
Am I understanding correctly that the blueprints indicate where Extreme Green would be placed within the building?
Absolutely, Your Honor. Yes, they do.
And counsel, fundamentally, why isn't this just a battle of experts? Your guy says one thing, their guy says another. Isn't that a factual dispute?
Sure. So there are a couple of reasons why, Your Honor. I think the first is that we don't even get to the question. It functionally doesn't matter whether or not the product is defective or not, because, again, we didn't warrant against it. And that's what the court found in the first instance. The second reason is that what their experts say, from a threshold standpoint, don't actually demonstrate that the product is defective. And it's their burden, in this kind of case, to establish that the product is defective before we have to respond. This idea that Mr. Montalto didn't provide anything is not correct. We just didn't. That's not the focus of the argument. That's not what the court relied upon. Their experts both acknowledged that they did not test the individual product here.
Right, but they said that the only thing that was different from any other construction was this use of Extreme Green.
Yeah,
Every
so
other component of this flooring was the same.
that's a if I may, Your Honor, sort of a rough paraphrase of what one of the two experts said. Mr. Fernopfel testified that he just didn't test anything that he could have, that he has in other instances done specific testing, and he just chose not to. The reason, importantly, that he did not is because he was originally retained for the case that is now proceeding in the Western District of Kentucky, where they are suing the manufacturer and the distributor because of the assembly. He was retained to test the assembly. And the allegations in that case are that the manufacturer and the distributor didn't provide them with the information that they needed in order to ensure that the assembly was installed correctly. And so his testing demonstrates that the assembly doesn't work. He then was hijacked for this case effectively and just said, yeah, it must have been this product. But completely acknowledged in his deposition testimony, which Rialto never cites, that he didn't do anything to reach that conclusion. The other expert, Mr. Skaug, says not that I can say for certain that none of these other issues or other items are at issue. He just says those are tried and true products, meaning they've been on the market for a while. That is not sufficient evidence to say that they are not the reason why there is a problem here. He acknowledged that anything as simple as a screw that was out of place could cause this issue. And the testing, and he in particular, the assembly that he used wasn't even the same shape and dimensions as the assembly was actually installed in the building. There's literally no evidence anywhere in the record that this particular product was the problem. I would point the court to the Teeters decision from, I believe it was the 6th District, that involved a very similar situation where they had experts who came in and said, I believe it was a garbage truck lift that failed. And they said, look, there's a problem with the assembly here. And I think it was this particular cylinder. And the court said, where's the evidence of that? And they said, well, it's just my opinion. And the court said, well, that's fundamentally not enough to satisfy your burden at summary judgment, and awarded summary judgment against the plaintiff because there was no evidence that that particular cylinder was the problem.
And you are at your time, beyond your time.
Okay.
If you want to.
Thank you very much, Your Honor.
Thank you. Mr. Penny, I did let him go about a minute over, so I'll give you another minute as well.
Well, thank you, Your Honor. I want to begin by suggesting that my learned friend may have been mistaken with regard to a statement he made with regard to testing of the assemblies. The expert reports document there are, and I can't recall the exact number, but 7 or 8, I believe it was, particular locations in the apartment complex where on-site testing of the assemblies in place was affected. And it was based upon those examinations and comparing them with similar structures at other projects that use the gypcrete to show the distinction between using extreme green and gypcrete and the differences with the same basic design of the floor ceiling assemblies to lead the experts to the conclusion that in place at the Rialto on Hurstbourne project, that these assemblies were acoustically deficient and that the cause, because all other potential causes in the experts' opinions were eliminated, was extreme green. So I believe that there is in the record sufficient evidence to demonstrate that, by circumstantial evidence, I should say, that extreme green was the problem, and it was done so by eliminating all other potential reasonable causes of the
Can
deficiency.
you explain from your perspective how the design warranty differs, if at all, from the merchantability and suitability warranties?
I can, Your Honor. The design warranty is whether or not it was designed to perform this function, and if the design was insufficient to perform the acoustic shielding function, then there would be a defect in the design. Suitability is not greatly different, but the suitability is whether or not this product was a suitable substitute for the gypcrete method of providing the insulation or the barrier for both fire purposes and sound insulation purposes in the floor ceiling assemblies. And merchantability is, as Judge Krause commented, is actually defined in the UCC, and we believe that this would not have passed in the trade for this purpose. The expert reports further, with regard to this point of suitability, did opine, contrary to what my
So
colleague mentioned.
I just want to make sure I fully understand your statement and your perspective there. Is it your perspective that Extreme Green is not merchantable as a floor ceiling product?
I would say that there is expert evidence from which a jury could conclude that, and the experts so opined. They further specifically opined that Extreme Green is not suitable to serve in this floor ceiling assembly as it was installed and as US LBM knew it was to be its use in this project.
Well, wait, it's not suitable because it doesn't meet the minimum building code standards, or it's not suitable because it doesn't meet luxury standards?
Both, I would argue. Now, obviously, the minimum building standards are lower than the luxury standards. But the evidence that was submitted by the experts, we believe sufficiently for the summary judgment 56C standard, but even if not, certainly for a 56E standard to respond to create a genuine issue of fact. So consequently,
You are at your
we
time.
respectfully request that the trial court's judgment dismissing Rialto's claim be reversed, including reversal of the denial on the indemnity claim, because Judge Gehring below held that only third-party claims were within that. We disagree, and reverse the denial of Rialto's partial motion for summary judgment, remanding the case for trial. Thank you, Your Honor.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Thanks. All right, the next case is Goodling versus Cincinnati Metro Housing Authority. Mr. Goodling, you will have 15 minutes to argue. You will also have the opportunity for rebuttal. Would you like to reserve any rebuttal time of your 15? How much time would you like to reserve? 5 minutes. Okay, I will keep track of your time. You'll see lights on the podium, and when you have a minute left of your initial time, that means, try to start wrapping up, and then the red light means that you're finished with your time, okay?
Good morning, Your Honors.
Good morning.
My name is Cortland Gunling, and my purpose here is to appeal dismissal by Hamilton County Municipal Court. And the court claimers the CMHA violates its own housing choice housing policies, approving a tenant with $1,000 unpaid water bills, incurring harm to me, financial harm. And the errors on the appeal was dismissed under Civic Rule 12B6, complaint states a claim, and dismissed under Civic Rule 12B7, tenant not necessary. On Civic Rule 8A, short and plain statement, I believe I fall into that. My CMHA policy required, I stated CMHA policy required full payment of utilities. I also stated a claim plaintiff informed CMHA of tenant arrears. CMHA approved RTA anyway in violation of their policy, and that incurred financial harm to me because I was unable to collect $1,000 from the tenant, because they're required to have a paid in full water bill before they can move into another unit, and it has to be submitted with the RTA. CMHA failed to follow through with their own policy, and I was unable to collect the $1,000. And on the to say the policy, they violated their own policy. They did receive notice from me when a tenant gave me the 30-day notice. Well, we're actually going through an eviction. I notified CMHA twice that she had an unpaid water bill of at least $1,000. They sent back, said they will pass that on. They never acted. In fact, the tenant had 2 RTAs. The first one failed inspection. She submitted another RTA. I sent them an email again claiming still your policy is they have to have that paid in full water bill with the RTA. They did not do it. It's because of their failure to do their own policy, I was unable to collect $1,000 that she owed on the water bill. And the claim where the tenant has to be involved into this, my claim is not with the tenant, it's with CMHA, because their policy specifically dictates that they have to have that paid in full water bill submitted with an RTA. That's been there for years. It's always worked. For some reason, this tenant, they did not do that. They totally ignored the emails. They pushed 2 RTAs through, total violation of their own policy. In fact, it also violates HUD Rule 24, CVR 982. Everybody's got to be treated as an equal with the property owners. No, all the rules go equal.
Are you
can't-
going after the tenant for the money?
Well, my attorney I had at the time, Darnett, we talked about, it's uncollectible. They have nothing. That's why they're on Section 8. There's nothing to collect. The only way we can collect is through Section 8. When they submit the RTA, they'll be rejected if they don't have the water bill. In fact, we had a tenant leave just right after this one, gave a 30-day notice. She needed a 4-bedroom apartment, and she submitted the RTA, and it was rejected because of the unpaid water bill. Worked just fine. She came back, paid the water bill, submitted an RTA, but then in the meantime, I had a 4-bedroom open up, and she went ahead and moved to my 4-bedroom unit, so everything was fine. But the system worked. They did exactly what they were supposed to do. Why they protected this tenant, I have no idea. I can't get no answer out of them. They should have followed their policy, and they violated HUD policy. And I'm requesting a reversal. I want this remanded for proceedings. I think CMHA should be held accountable for their own policies, because if they didn't violate their policy, we wouldn't be here today, and then the water bill would have been paid. And like I say, I want to proceed. I want a law to redress for agents' policy to violate their own policy. I want this to go to trial.
Okay. Anything else? You have some additional time if you want to use it.
I guess the only thing I say is that everybody within the system, with property owners, don't like to use landlords, I like to use property owners instead. The rules should, government money, everybody should be treated as an equal. All rules should be applied the same to everybody. No questions asked. And I do not understand why they let this tenant slide without paying the water bill. And in fact, there was this, I'll say, one email that she flat out lied to me about. She said, well, you're supposed to submit the bill. I said, no, your policy dictates, it's on the claim. It's on the RTA. The tenant has to provide that, not the property owner. The tenant does. And they just completely ignored that policy and let it go through. And it needs to be corrected. They need to be held accountable for their actions. That's why I didn't go after the tenant. I'm after CMHA because they created this mess.
Okay. All right. Well, thank you for your argument. You do have some time for rebuttal.
Okay, thank you.
All right, thanks.
Hello, Your Honors. May it please the court, I'm Everett Jones on behalf of CMHA. The trial court correctly dismissed this complaint that is one sentence long, cites no law, alleges no duty or facts, names no proper party other than CMHA. Even generously construed, it identifies no legal claim. Only allegations within the 4 corners of the complaint may be considered, not additional materials or arguments raised later, as was raised today. The landlord's attempt to expand the record on appeal by citing attachments and new arguments confirms the complaint's fatal flaw that it never stated a valid claim in the first place.
What's the relationship between the landlords or property owners and CMHA? Is it contractual?
Yes, based on the HAP contract, CMHA pays the landlord a tenant's a portion of rent. The tenant pays their own rent. However, it's important to note that federal law explicitly states that CMHA or PHAs, public housing authorities, are not liable and have no duty to enforce tenant utility payments.
What other duties do they have to the landlords under this agreement?
Under the agreement, the duty is to pay the HAP contract, housing assistance payment, to the landlord.
And nothing beyond that?
Nothing beyond that.
Was that a basis for the motion to dismiss that you filed, the immunity under federal law?
That was one of three. The trial court did not specifically cite its reason for dismissing, but we moved to dismiss based off of the facially deficient complaint, also the failure to join the tenant as an indispensable party. CMHA wants to also note, as a matter of public record, the landlord also sued the tenant directly for the water bill in 2024, which underscores that the tenant is the responsible party. If I remember correctly, it was eventually dismissed for want of prosecution. However, matter of public record, there's some more history here, as the tenant also sued the landlord for some sensitive allegations relating to privacy. It's also noted that although it is CMHA's internal policy to make sure that a water bill is paid before approving an RTA, CMHA has discretion based on facts. And in this case, the pending litigation between the landlord and the tenant was going on for months. The agency did not want to hold up the tenant's voucher or risk it expiring or risk her being able to move, especially considering the pending litigation between the tenant and landlord.
Why wouldn't he be given a chance to fix this instead of dismissing with prejudice? Why not dismiss without or allow him to fix the problems in the complaint before it's dismissed?
Even if he's allowed to amend the complaint, and I'm assuming by adding the tenant, federal law independently forecloses liability to CMHA, very explicitly, quote, the owner is responsible for performing all of the owner's obligations under the HAP contract and the lease. The owner is responsible for paying utilities and services. And so CMHA's position is, even if the internal policy was overlooked, that doesn't automatically convert into a cause of action and make the agency liable for the tenant's obligations.
What about this claim that he was misled by CMHA about the tenant either paying or owing the water bill?
I don't know anything about those specific allegations. What I do know, specifically the new facts that never appeared in the complaint or record, the plaintiff hasn't pled a duty, a breach, no causation, and dismissal was based on the complaint as filed, not the additional facts he later tried to remedy.
And that's my point. I mean, isn't that at least initially, the more, I guess, appropriate remedy to allow him at least an opportunity to fix it before it's just dismissed?
Well, even on that basis, again, I don't know on what basis the trial court dismissed it, but in the motion to dismiss, we also argued the federal liability, foreclosing federal liability. So the judge may have had that in mind, in addition to the confusing allegation. And, you know, I also want to mention the matter of confusion, the misstatements of the procedural dates. While they're not dispositive, the pattern underscores the broader issue is that the pleading lacked clarity and accuracy. The agency has a right to know why it's being sued and doesn't have to guess at what the plaintiff is trying to get to or allege.
Counsel, is there a potential standing problem as well in this case? I noticed that the complaint was filed in Mr. Gunling's name individually, but one of the attachments was a bill sent from Dearborn Properties, I believe, to who appears to me to be the tenant. The person's name was not included in the complaint, but looking at it in the light most favorable, I can infer that this person was in fact the tenant. Would Dearborn Properties be the entity that is owed the water bill as opposed to Mr. Gunling individually? And would CMHA's contract be with Dearborn Properties, or is it with Mr. Gunling individually?
I believe you are correct. That's one of the many problems with this complaint, and the confusion is the proper party, I believe, is the LLC. I believe CMHA's HAP contract, I'm going from memory, is with the LLC as well. However, based just facially, at the time the motion to dismiss was, filed, CMHA didn't believe it. The complaint pled proper duty, causation, and so to get into those facts, the agency didn't even go that far into the situation at that time.
Thank you.
Thank you.
Thank you. Mr. Gunling, you have
Okay,
about
I want to
10 minutes for rebuttal.
Couple of things here. About the Dearborn properties in my name, I'm a DBA, not an LLC. So I can file it under my name or under Dearborn Properties. It's still doing business as Dearborn Properties. So there's no LLC involved at all. And with the water bill comes through me because I own the meters. When we rehab these buildings, all the new meters are put in, and Cincinnati Water Works does not install meters. We have to, and we own them. So we just bill exactly what the figures are. If we get from Cincinnati Water Works, they publish them every year, and we just use those figures, no profit, no tax, just to try to cut the cost down on the apartments and water bills. That's our biggest expense besides property taxes is water. And it works. It drops our bill about 30%. But CMHA does not have, he claims that they have discretion to enforce the rules as they want. They don't have discretion. The rules are there for a reason. If you're going to sit there and do discretionary rules, then that's just going to create discrimination. You're going to discriminate from one property owner to another. It's got to go across the board. That doesn't fly. To sit there and block me from collecting the money that was due from the tenant by not enforcing a rule that worked, and then enforcing it to another landlord, that's discriminating back to me. They have no basis to sit there and say, we're not going to enforce this rule. They have to. They're under HUD rules. They have to follow the rules. And to sit there and to say you're going to do one rule to another, that's absolute wrong. You can't operate like that. That just turns it into discrimination. That's all I got to say. Thank you.
Okay, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Thank you. Okay, our final case is State versus Lee. Ms. Peters, would you like to reserve some rebuttal time?
Yes, Your Honor, 5 minutes.
5 minutes, okay.
May it please the court, Laura Peters on behalf of appellant Preston Lee. In this case, Mr. Lee was convicted of endangering children under RC 2919.22B1, which prohibits abusing a child. The evidence in this case was insufficient to sustain a conviction. It was contrary to law, and that it was against the manifest weight of the evidence. We raised 2 assignments of error. I would like to concentrate on the second one, which the insufficiency in the manifest way, but it'll waive in the first assignment of error as well. In this case, as I said, he was charged with 2919.22B1. There are 3 elements to that offense. 1, there is a child, and if you look at the video, it's pretty evident it's a child. 2, an affirmative act of abuse. And 3, that was recklessly committed. In this case, what we contend is that there is no evidence of an affirmative act of abuse towards the child. In this, Mr. Lee readily admitted that he threw a brick through his own front storm door. He also stated...
Was that act directed to any person?
No, Your Honor, it was not.
Was it reckless?
It could be termed to be reckless, but not, he threw the brick through the window because he had been locked out of the house. He was going through marital problems with his wife, and this was their marital residence. and she had locked him out of the residence. So he threw the brick through the storm door. As he said, he was.
Just so I understand, is the only element that you're disputing here the affirmative act of abuse? Or
Yes.
you're not disputing the mens rea here?
Well, yes, I would dispute the.
The recklessness piece?
Yeah, the
Okay.
recklessness, yes.
Well, let me go back to the recklessness. How is throwing a brick through a glass door where you have no idea of who's behind that door not reckless?
Well, my client said that there was no one behind the door. He was there, he was in front of the door, and when he would talk to Officer Bolt, he said there was no one present. So he can't be reckless in that it was going to immediately cause any harm. And in fact, what you have in this situation is you have his admission that he threw the brick through the window, or through the storm door, the bottom pane of the storm door window. What you then have is Officer Bolt observing that there's a cut to the child, but you have no evidence, no testimony of how actually the child got cut.
Wasn't it circumstantial evidence? I mean, there was glass everywhere, and the
Right, but
child
you
got
have to
cut.
infer that the child got to the glass, and you have to infer that the child was cut by the glass.
Why can't you do that?
Well, because this is a child. A child can be injured, gets injured, they have scrapes and bruises, and so.
But from a sufficiency standpoint,
But it
isn't that
also-
one, looking at the evidence in the light most favorable to the state, which we're required to do, isn't that one reasonable interpretation of the evidence? I mean, you're asking us to assume that this child got injured some other way, when there's
But-
literally glass laying on the floor.
There's glass on the floor, but again, it requires an affirmative act towards the child. The child wasn't present. We don't even know how long the glass
But
was on the floor.
Aren't we looking, so we're really looking at recklessness here, right? That seems to be the crux of the issue in this case of whether or not he was reckless in throwing the brick.
I see it both ways, that it can be, because in order to be abused, there has to be, and that is something for this court to look at, is because the term abuse itself is not defined in the statute. Now, in State versus Howe, they took that this is sort of a cruel or violent act that's affirmative committed towards a child. And in most of the cases that you
So is your point then that because his testimony, which was unrefuted by any other evidence, that he didn't see anyone on the other side of that door when he threw the brick, is your perspective then that he didn't commit an act towards anyone and therefore he didn't commit abuse towards a child?
In essence, yes, because this was his marital residence. If he wants to throw a brick through his own storm door, he can. There's nothing that,
If the child was standing right there, and there was evidence that he saw the child, and he threw the brick through the window, and the glass cut the child, wouldn't that be enough evidence of abuse?
that would be an entirely different case, Your Honor.
Well, doesn't that then go to the mens rea? I mean, cruel or violent behavior, throwing a brick through a window is cruel or violent behavior if you have the mens rea to go with it, right? You're injuring a child.
But you're cutting off that it has to be a cruel and violent to the child. Now, if the child is not there, you can't say that that's an affirmative act of abuse to the child.
But the child was there. I mean, doesn't he assume the responsibility by going around throwing bricks through glass windows?
Respectfully, Honor, there is no evidence of when there is no timeline in this case. We have the police showing up because of a report of a domestic trouble, because of my client throwing a brick through the door. But what we don't know and what we don't have is any evidence is when the brick was thrown, how long the glass has been on the floor, when the child got there, how the child got any type of injury.
So
there-
are you suggesting it's the state's burden to prove that the child was present when the brick was thrown through the door?
Absolutely. It's absolutely the state's burden to prove an affirmative act of abuse toward the child. And in this case, we don't have any testimony. You have one witness who testified, and that was Officer Bolt.
But isn't the fact that even the child wasn't there when the brick actually got thrown, the residue that was left from the brick, the glass on the floor. If the child comes upon that as a result of your client's actions, doesn't that constitute abusive behavior?
But again, that goes into the sort of, then it can come into the reckless and the abuse, because there's no evidence of why my client should have even expected the child to be there at all.
Well, I mean, that seems to go to kind of the definition of recklessness. That's why you don't do reckless things, because you don't know what may result from doing these reckless things.
But it's with heedless indifference. So if you don't ever expect a child to be there, how can you have that reasonable forethought that the child will be there and could potentially get cut by glass, if that's in fact how the child was injured in this case? If you look at the actual testimony and what the evidence was admitted at trial, you're going to see that there's an absence of evidence as to how the child got this injury to his hand.
Could he reasonably believe that someone would be there? Is there enough evidence in the record to reasonably believe that someone?
Well, it was the
would be-
marital residence, so potentially his estranged wife, yes.
Well,
But
wouldn't,
that's, again,
wouldn't someone have to be there? I mean, when the officer arrived, he said that he had gone somewhere, he came back, and they had locked him out of the house. So doesn't that, in the light most favorable to the state, imply that someone is in the house to have locked it?
no, I think that's a little step too far, Your Honor, to be honest, because, yes, my client said he went to go get gas. When he came back, they had locked him out of his house, but they could have locked him out because they went somewhere. So again, we don't know how long.
But if we have multiple competing inferences, aren't we required under the sufficiency standard to look at it in the light most favorable to the state?
Under sufficiency, but then I would say that this case is one where it's against the manifest weight, that there's too many questions, because we don't know a lot about how this actually transpired, because we don't have the evidence. All we have is the officer who comes in after the fact, and you don't have, so the only other evidence you have, the only other clip of somebody else besides my client talking is the paramedic, which we assert doesn't fall under either the 8034, which is what the trial court admitted it under, and which the state seems to have conceded that it doesn't qualify under
But isn't it
803.
entirely, regardless of whether it was properly admitted or not, isn't it entirely duplicative of the officer's testimony? Because the officer himself said that he saw the cut on the child's hand.
The officers, yes, he did say he saw, so it could be considered duplicative in a sense, other than that he says that the child was injured. And I believe the officer said he did see a little bit of blood, to be honest with you.
So what real difference does it make that this testimony was admitted?
Because it makes it seem more, to me, it related it more to the glass than to anything else, because he causes as a cut versus an injury or a wound. I mean, and maybe I'm playing semantics here, but when you have very little evidence as to what actually transpired, anything that tips the scale towards the state is more than harmless. It's actually prejudicial. So we would say, it wasn't admissible under 8034 or 8031 because it wasn't a spontaneous statement, which is what's required under the rule. It was after some consideration. So based on the lack of evidence, we would urge this court to either say it was insufficient or reverse on the manifest weight. And I would like to reserve the remainder of my time.
Okay, you'll have about 4 minutes.
May it please the court, recklessness involves consciously disregarding a substantial and unjustifiable risk. And here, the brick was thrown at a residential home that we know Mr. Lee was familiar with, having resided there according to the evidence. And
What evidence would have suggested that a child would be present at the time that the brick was thrown?
Mr. Lee's familiarity with that particular home and the fact that police have been there
Well,
before.
he said that he resided there with his ex-wife. There was no mention of a child. So what evidence would have proved his mindset vis-à-vis the child when he threw the brick?
Your Honor, I think with the mental state of recklessness, if you are throwing a brick in a home, that right there shows that you are engaged in an act consciously disregarding a substantial risk of harm to anyone that might be present.
And so is it enough that he, if I agree with you, is it enough that he could have anticipated that a person could be harmed by this? Or because this is a child endangerment charge, does he need to anticipate that a child could be abused by this?
Anytime you throw a brick into a home, a child could be residing there. We don't have to actually show the child. It would be me wanting to celebrate a Bengals Super Bowl victory, so I fire a gun in the air. And what am I doing? I'm consciously creating a substantial risk of harm. That bullet has to go somewhere. I don't know where. I don't see any victims. I don't see a
Child endangerment, with its recklessness mens rea, does not require any sort of mindset towards a child.
It can't, Your Honor, otherwise I don't know why we would have the offense, because we're talking about the mens rea of recklessness, which we can infer that there are people in a home, and likely there could be children in a home, and anytime you throw a brick into a home, you could strike and seriously injure residents at home, and many children are residing at home. And I think that cannot be the way the statute is read.
Counsel, if it had not been a child, but instead a police officer behind the door, and the brick comes flying through the glass and the officer is hurt, could he have been charged with assaulting a police officer? And he had no idea the officer was behind the door and he threw the brick.
Your Honor, yes, I believe what happens is the status of the victim. If it happens to be a child, the appropriate charge would be child endangerment. If it happens to be a police officer, then it would be the appropriate charge depending on the status of the victim. But
So if the
again,
person has no idea that a child is there, you're saying, or would have an idea that the child might not be there, and the child happens to be there, that's enough?
that's recklessness.
Okay.
Right, you're unconscious of, when you unconsciously engage in a substantial and unjustifiable risk, and that's what happened here when you're
How do
throwing a
you
brick.
square that position with the language in the statute defining recklessness, which requires a person to anticipate that their conduct is likely to be of a certain nature? Wouldn't the requirement that they anticipate the nature of the conduct include the child, the police officer, or the identity of the victim?
I believe that answer is no, because you are consciously engaging in a substantial and justifiable risk. The consciousness is throwing a brick into a resident, and you know that that could injure any number of people that could be in that resident. And this happened to be a child, and I still think anytime you throw a brick into a home, you have to, the reason for that statute, a child could be in that home.
You have to assume that a child could be there if it's your own home and a child doesn't reside there?
Your Honor, it could, yes.
If I take conduct,
Yes.
let's say that I accidentally lock myself out of my house and I need to take some measure to break into my home to get back in, and I know that a child doesn't reside in my home, I have to assume that a child could be inside when I take those measures to re-enter?
When you in anger throw a brick at a home, then I believe that you are engaged in a substantial and unjustifiable
But in
risk.
making the choice of how to re-enter back into my own home, I have to assume that a child could be inside it, even if a child doesn't live there?
Your Honor, I wouldn't suggest taking a brick and just indiscriminately throwing it. In your scenario, if you're locked out of your own home, you're likely going to be by the window making sure no one gets hurt, and you definitively know no one is in there. But then we might as well just forget about recklessness in all these cases, because whenever someone acts recklessly, they're putting in danger someone. I mean, when you fire a gun in the air, you're putting someone in danger, and the bullet might land hopefully harmlessly, but still you are engaged in a substantial and unjustifiable risk if you fire a gun in the air and you don't see anyone around, but it might be in a residential area. That's a substantial and unjustifiable risk. So is throwing a rock in somebody's home, he was familiar with the house, and you could infer that maybe he knew a child was there or could be there. I just think that this crime was committed once someone in this situation indiscriminately picked up a brick and fired it in a residential home. And that's engaging a substantial and unjustifiable risk. And that fits the mens rea element of recklessness. Because we don't have to identify each person, I don't think, in the home. I don't think that's the requirement of the statute, or you're going to really wipe out the almost a lot of offenses that have recklessness as the mens rea, and the other part of the offense is there's harm that's caused to someone. We don't know who that someone is, but the point is you're throwing a brick at a home, you might be firing a weapon into a home, any number of things. The law doesn't require that you know precisely is who in the home.
A typical principle of statutory construction is that when we have a mens rea element for a statute, we apply it down the line to each element. Why would we not do that here?
I don't know if I believe this. The statute requires a culpable mental state of recklessness, that he acted recklessly. So Mr. Lee took a brick and fired it in a residential home. To me, that is engaging in a substantial and unjustifiable risk of harm.
Well, what is the
I don't
certain
see
natures?
beyond that.
What is the certain nature that you would identify? Because he was charged with the very simple crime of child abuse. So what is the certain nature that he was supposed to anticipate and that you believe that the state proved?
That it's a residential home and any number of people, including children, could have been inside the home. That's
So
what the
it's-
statute's saying.
I know
that-
we're asking this again, because the unjustifiable risk is that the person's conduct is likely to cause a certain result. So the certain result here would be the injured child, right?
Right.
Okay, so you're saying by throwing the brick, even without evidence that he knew there was a child there, that his conduct is likely to cause an injured child?
Right, because if he knew there was a child in there and fired the brick, then you're talking about that was a conscious object to engage in that act, and that would be the culpable mental state of purposely. And that would be purposely causing harm to a child. If
he knew there was a child in the
and
house?
fired the brick right at the child, yes.
Well, right at the child. But if the child, you're saying it would be purposely if he knew there was just a child somewhere in the home?
It might be, it
You have to-
depends on the circumstances, right? I mean,
Okay.
but
But
you
the
can
certain
infer,
result,
maybe.
under recklessness is that a child would be injured, right?
Right, that there's certain.
Not just
result.
somebody, but a child.
Yes, but I
Okay.
believe that you can do that when you're firing a brick into a residential building, that qualifies as reckless conduct because you engaged in a substantial and unjustifiable risk that could result in harm and possibly to a child since it's at a
Well,
residence.
not possibly. It doesn't, we're requiring harm to a child,
Harm to a child, right?
Right.
Okay, well,
not
that's,
just possibly.
but it's a risk of harm
Yeah.
to someone, and, a child is included in that. Any number of persons in that home could have been injured when somebody indiscriminately throws
Is
a brick
could
at
be
a house.
enough? I mean, the definition requires a substantial risk. Is it enough that this could happen?
Well, that's the idea of recklessness. You consciously fire a brick into a home then the law requires you're going to be responsible for that result because you engaged in a very dangerous activity.
So people should be on notice that if they throw a brick through their own window to try to get back in their house, they've committed a crime?
Not necessarily because it's their own home, and I don't think that they're going to indiscriminately throw a brick anywhere in their home. I think that's a different factual scenario. A person locked out of their home, well, they are taking a risk if maybe somebody was home and shouldn't have been home, and they just wing the brick and it hits somebody and they didn't realize somebody was in there. That's a different story.
But how is that a different story? Because the only
No.
evidence in this case was that Mr. Lee said he didn't see anyone there when he threw the brick and he was locked out of his own home.
You can, a trial court is free to accept or reject part or all of the testimony, but the heart
Well,
of
that
this
wasn't his
testimony.
testimony, that was his
The
statement
statement,
on the body worn
Right,
camera.
but right. And so maybe the court, I don't know, reject that part of it. I'm not sure. What I do know is that Mr. Lee took a brick and fired it indiscriminately into a home.
And when you act in that kind of reckless manner, you get what you get.
And you get what you get. That's yes. Yes, Your Honor. That's why we have a culpable mental state of recklessness. If you fire a gun and you might think it's safe, but it's near a residential area, you're right, you get what you get, you know. It could fall indiscriminately and not injure somebody, or sadly it could. You know, I always harken back to that little girl that was School for Creative and Performing Arts, a drug deal, and a gun went off between the two drug dealers, missing them, and struck her right in the heart, almost a mile away. They got what they got then. I mean, I know they were engaging in an inherently dangerous criminal activity that's not on par with this, but indiscriminately throwing a brick is still dangerous activity. I mean, it's not drug dealing and shooting guns at each other, but it's still dangerous to throw a brick into a home. And I think that's what the law was protecting here. But, is there any questions?
All right, thank you. Ms. Peters, you have 4 minutes.
Just briefly, Your Honors, as you've all pointed out, the definition of recklessly requires a heedless disregard of a known risk
Where are you getting that definition from?
from 2901.22C, the definition of recklessly. So it calls, when with heedless indifference to the consequences, he perversely disregards a known risk that his conduct is likely to cause a certain result or is likely to be of a certain nature. So if the only evidence is that my client shared a marital residence with his wife and that there is no indication that a child belongs there, I don't see how he could have, and he's locked out of his house and he throws a brick through his own door, that he could have known there was a risk of a child to be present.
So you're saying if there was evidence, some sort of evidence in the record that he knew a child lived in, or was in the home or lived in the home, that would have been enough?
If the child was in proximity, I would say to the door as well, or could have been.
Why does he have to be in proximity to the door? I mean, after the brick is thrown, glass is all around, as the child comes wandering down several minutes later and gets cut. Isn't that still the same result?
But again, that's not an affirmative act of abuse to the child. Damaging your own storm door when the child isn't in any sort of proximity and could be endangered, could not be deemed to be an affirmative act of abuse towards the child.
Is
which
this
what this statute
contextual?
requires.
I can envision situations where, I don't know, a 2-year-old might be locked in a house on their own and the parent needs to break the glass in order to get inside. And perhaps that is not reckless under those facts. Or perhaps there is another parent inside, but the parent is needing some help, and the person might break in and instruct that other parent to clean up the glass. I mean, isn't this highly contextual to what the person's mindset was at the time?
Yes, I would, there is some, yes, you have to place it in its to context, especially if you consider that it has to be an affirmative act of abuse.
What is the evidence of Mr. Lee's mindset in this case? What do we know?
That he's indicated that he was tired of the situation with his wife and that he got locked out. And that.
And do we know what he thought or saw vis-à-vis who might have been in the house at the time he threw the brick?
When he talked to Officer Bolt, he indicated that he threw the brick through the storm door and that there was no one present. That's what he stated. No one was present. So the evidence here is insufficient and is certainly against the manifest weight to convict him of endangering child as a form of child abuse.
So you're arguing that if the child, even if the child was in the house, your issue is that we don't know if the flying glass cut the child or if the child, like 3 minutes later, walked into the glass and cut himself. And so.
Or 30 minutes
to you,
later,
that's
or an
different.
hour later, or,
The
yes.
flying glass, you think, that would be abuse?
I could see in certain circumstances where it could potentially be, because again, I don't know that if this was actually this wasn't an act committed toward the child.
Well, now you're talking about the recklessness piece, right?
Well, I'm actually talking both, because even at State versus Howe, the way that the statute has been delineated in case law is that there's the three elements, and that's that there's an affirmative act of abuse to the child that's done recklessly.
Right.
So, again, when you have to have an affirmative act toward the child, if you're throwing the brick and you don't know a child is there and they get hit by flying glass, I'm still not sure that that's abuse of a child. Maybe it's a different
Well, what
criminal
if you know the
offense.
child's in the house? See, what if you know the child's in the house? Let's say you know the child's in the house, and the evidence is that the child didn't get hit by flying glass, but 2 minutes later stumbles and falls on the glass.
I would say that's not child endangering under B1 because it's not an affirmative act toward the child.
Okay. All right.
All right?
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day.